This is a non-statutory public meeting to share information on the comprehensive zoning bylaw. This is the first of, I believe, 3 or 4 such meetings that we'll have. It's a very extensive and expansive document when it all comes to us. So I'll read the notice of collection. Personal information collected as a result of this public hearing and processes collected under the authority of the Planning Act and will be used to assist in making a decision on this matter. All names, addresses, opinions, and comments may be collected and may form part of the minutes, which will be available to the public. Questions regarding this collection should be forwarded to the Director of Planning Services. The purpose of public meetings is to present planning applications in a public forum as required by the Planning Act. Following presentations by the applicant, committee members will be afforded an opportunity to ask questions for clarification or further information. The meeting will then be open to the public for comments and questions. Interested persons are requested to give their name and address for recording in the minutes. Interested members of the public can email the committee clerk or the assigned planner if they wish to be notified regarding a particular application. No decisions are made at public meetings concerning applications unless otherwise noted. This public meeting is held to gather public opinion. An exception to the rule is contained combined reports. I won't read the rest of that because indeed there is no recommendation. This is for information, I believe, if I'm not mistaken. Public meeting reports are provided to inform the public of all relevant information. Information gathered is then referred back to Planning Services staff for the preparation of a comprehensive report and recommendation to the Planning Committee. This means that after the meeting tonight, staff will be considering the comments made by the public in their further review of the application. When this review is completed, a report will be prepared making a recommendation for action to this committee. The recommendation is typically to approve with conditions or to deny. The committee then makes a recommendation on the applications to City Council. City Council has the final say on the application from the city's perspective. Following council decisions, notice will be circulated in accordance with the Planning Act. If a person or public body would otherwise have an ability to appeal the decision of the Council of the Corporation of the City of Kingston to the local planning appeal tribunal, but that person or public body does not make oral submissions at a public meeting or make written submissions to the City of Kingston before the bylaw is passed, that person or public body is not entitled to appeal the decision. So the public meeting that we're calling to order is the new zoning bylaw project. And it was outlined in information report number 2229 to council and report number 21022 to planning committee. Staff and planning services are in the third and final phase of the new zoning bylaw project, the new ZBL, with the ultimate goal of bringing a final document to council's consideration in early 2022. It is important to note that the timeline may be impacted should there be direction to add additional public engagement to the overall project, or if the additional elements need to be researched that are currently outside the scope of this project. The purpose of this report is to provide background information and obtain feedback from the public and members of the Planning Committee with respect to the topic of schools and places of worship, in order to inform how these items will be addressed in the second draft of the new ZBL. When it is released to the public, which is anticipated in mid-2021, this paper also includes potential amendments to the city official plan. A city-initiated official plan amendment is anticipated to be submitted at the same time as the release of the second draft of the new zoning bylaw, which will be processed concurrently with future statutory public meetings, considering both the proposed official plan amendment and the new zoning bylaw. So, the public meeting is before us. It's non-statutory. Is who among the, yes, Elizabeth is going to steer me straight. Go ahead.
Mr. Chair, I just wanted to remind you, staff had requested if we could deal with the public meeting regarding the Environmental Protection Act prior to the schools and places of worship.
I was wondering where that was. So that's good.
No problem, Mr. Chair.
Okay.
I do believe that Ms. Flaherty is with us this evening to speak to that one first, as well as Mr. Odie.
That was going to be my next question that you anticipated. Who would like to speak to this from staff? Ms. Flaherty.
Yes, thank you. Elizabeth, are you able to share the presentation, or should I share it from my slide? There we go. Perfect. Thank you for joining us today for the first round of non-statutory public meetings on the new zoning bylaw project. My name is Laura Flaherty. I'm a project manager in planning services. My primary responsibility is the city's new zoning bylaw project. Next slide, please. As a quick overview of the anticipated agenda for this evening, I'll be providing some background information about the new zoning bylaw project. Niall Audie will present information related to the discussion paper on environmental protection areas in the Ribbon of Life. We'll then take questions and comments from members of committee, then members of the public. Myself and Chris Wicca will then present information about the second discussion paper on schools and places of worship. The question and comment period will follow. Next slide, please. So I just wanted to start off the public meeting this evening with a brief background and introduction to the new zoning bylaw project and where these discussion papers fit in, just for everyone to have context and understand the next steps and what we're going to be doing with the information and the feedback that we're receiving this evening. Next slide, please. So as most people are aware, in Kingston, we have 5 main zoning bylaws that apply across the municipality. These bylaws are legacies of the former townships and predate amalgamation. 3 of the existing zoning bylaws were adopted in the 1970s, and 2 of the existing zoning bylaws were adopted in the 1990s. The patchwork of zoning that applies across the city is inconsistent with different rules applied to different areas. The existing zoning bylaws also predate the current official plan, which was enacted in 2010. This means that many of the existing zoning bylaw provisions that are in effect do not reflect the current official plan policies. And at present, there's a disconnect between the vision for future growth of the city and the provisions of the existing zoning bylaws. Next slide, please. When we talk about a new zoning bylaw for the city of Kingston, we have a vision to harmonize, simplify, and modernize the zoning framework across the municipality. Harmonizing zoning provisions is more than just a consolidation exercise. It means we will carry forward some of the existing zoning bylaw regulations, but it also means that new and updated regulations will be created to ensure that the zoning bylaw aligns with the vision established by the official plan. Simplifying the zoning bylaw means that language and maps will be modified to be as user-friendly as possible. Requirements will be clearer and more easily understood. Modernizing the language in the zoning bylaw means that the terms will be updated, uses will reflect current trends, and will be written in a way that allows for innovation for future trends and uses to thrive. Next slide, please. The new zoning bylaw has been talked about for many, many years. Phase 1 of the project established the strategic direction for a new zoning bylaw and created the direction for a future consultant. The strategic direction was largely focused on the consolidation of the existing zoning bylaws. Phase 2 of the project was led by an outside consulting team and resulted in the creation of the first draft of the new zoning bylaw, which was released to the public in October of 2016 with extensive public consultation at that time. Following the release of the first draft, the project was put on hold so that staff resources could be directed to other policy projects that have impacts on the second draft of the new zoning bylaw. We're now in phase 3 of the project, which is being led by staff and planning services. Next slide, please. While the initial direction for the zoning bylaw project was more of a consolidation exercise, phase 3 of the project has expanded the scope to ensure that certain topics are given a tweak and other topics are given a rethink. Tweaking some of the requirements means that they may be updated to better align with new policies, or that the approach has been modified in a manner that maintains the intent of the policies, but is done so in an alternate format. Rethinking some of the policies means that new modern ideas will find their way into the new zoning bylaw. It gives us the opportunity to create new zoning bylaw provisions that can propel us forward towards the realization of the vision of the official plan rather than being rooted solely in past practices. Next slide, please. We're at the beginning of public consultation in phase 3 of this project. So the 2 public meetings tonight are the first of 4 public meetings about discussion paper topics. The second meeting is scheduled for Wednesday, June 23rd, and will focus on parking standards, tiny houses, shipping containers, and additional residential units. Following these public meetings, staff anticipate releasing the second draft of the new zoning bylaw to the public this summer. Public consultation on the second draft will follow the summer and fall, with a statutory public meeting at Planning Committee in early fall, followed by a special meeting of council. After all feedback has been received on the second draft, staff will work to prepare a third and final draft, which is expected to be presented at a final statutory open house, public meeting, and to council in early 2022. So the feedback that we will receive tonight on the 2 discussion paper topics is feedback that staff are looking forward to from the public and members of Planning Committee, and it will certainly help to inform how we approach these topics when we release the second draft of the new zoning bylaw. Next slide, please. There are many ways members of the public can participate in the new zoning bylaw project. We have a project website along with a Get Involved Kingston webpage dedicated specifically to this project. Staff are also maintaining a project email list where updates are sent when new documents are published and events are scheduled. Written comments can be sent via email or mail, and staff are available to speak on the phone or meet virtually with interested members of the public. Finally, members of the public can virtually attend future events and public meetings. Next slide, please. And I am going to pass it off to Niall so that he can do a presentation on the environmental protection areas and ribbon of life.
Just checking in that everyone can hear me this evening. Perfect. So thank you, Laura. And I am here to introduce the ideas that we are contemplating for the second draft to implement the existing intent of the official plan policies into the second draft of the new zoning bylaw. Next slide, please. So I'm going to be introducing proposed official plan amendment that would allow for the new zoning bylaw to better implement the intent of the Riparian Corridor policies within the official plan. The second draft is proposed to transition the protection for riparian corridors, which are lands within close proximity to water bodies, from a mapped zone to a text-based regulation. And this change from mapped to text-based regulation would expand underlying zoning permissions to approximately 4,200 properties within the municipality without creating legal nonconformity or financing issues, while still maintaining the same protections for riparian corridors. So I think that's very important to say up front and to keep in mind as we move forward in this presentation. Next slide, please. This presentation is going to start fairly high level with a quick introduction of the provincial policy statement, and then an overview of our existing official plan policies related to this topic. A quick summary of the existing patchwork of zoning bylaws that are in place today, and then an overview of the first draft of the new zoning bylaw, together with a summary of public comments that we had received since 2016. We're then going to go through 5 implementation issues that we identified as we started to work on the second draft, and we're going to conclude with a summary of the proposed second draft. Next slide, please. So the provincial policy statement forms the basis or foundation for land use planning policy within the province of Ontario. Section 2.1 regards natural heritage, and this is where the province has identified the features that are of provincial significance together with their adjacent lands, which are lands within a specific buffer or radius around those features that have the potential to impact the heritage features. Generally, Section 2.1 prohibits development within or conditionally prohibits development within the natural heritage features in the adjacent lands. Section 2.2 of the PPS regards water and provides the direction to protect, improve, restore the quality and quantity of water at a watershed scale, and generally directs development and site alteration away from sensitive water features. It's important to note that Section 3.1 of the PPS regards natural hazards, and there's commonly overlap between natural hazards and natural heritage features in areas of water. But tonight we are focusing on natural heritage features, and so we won't be discussing much about natural hazards. Next slide, please. Our official plan then builds upon those policies of the provincial policy statement in Section 6.1, which establishes our natural heritage system. So this chart lists the various natural heritage features in our official plan and categorizes those features as either an A category or a B category. Development is generally prohibited within features identified as A and is conditionally prohibited within the B categories. In order for development to proceed in B features, it would need to be supported by an environmental impact assessment that determines that there will be no negative impact to the feature. This chart also introduces or specifies the adjacent lands for each of the applicable features coming from the provincial policy statement. Of particular note, riparian corridors are identified in our official plan as a natural heritage A feature and are generally to be protected from development. Next slide, please. Our official plan then takes those natural heritage A features that are to be protected from development and places them in an environmental protection area designation. This is shown on Schedule 3. The EPA designation prohibits most forms of development. However, the EPA designated lands that relate solely to a riparian corridor are a little different. Our official plan allows these EPA riparian corridor areas to be developed in accordance with any other applicable land use designation that occurs on a property. So despite riparian corridors being identified as natural heritage A feature and appearing in the environmental protection area designation, they are not protected to the same level or status as other natural heritage A features. Section 3.9 of the OP gets into waterfront protection, and this is the portion of the official plan that introduces the concept of ribbon of life, which is generally considered to be a 30-meter naturalized buffer around water bodies and wetlands. Ribbon of life are lands that have very high ecological significance. They offer habitat, they offer opportunities for migration and transportation through corridors, offer opportunities for stormwater infiltration and water quality management, stream shading, those types of things. So very important. For the purposes of our official plan and the discussion here this evening, the concept of ribbon of life and riparian corridor and 30-meter water body setback are generally interchangeable, and they refer to environmentally sensitive lands in proximity to water bodies. Schedule 7 of our official plan shows where riparian corridors are located, and they are shown as a 30-meter buffer around water bodies and various forms of wetlands. Next slide, please. As Laura mentioned, there are 5 main zoning bylaws in effect within the city of Kingston today, and they are generally fairly outdated. Specifically with respect to water body setbacks, Zoning Bylaw 8499 that applies to the former city of Kingston doesn't have a water body setback. And this ranges up to Zoning Bylaw 3274 for former Pittsburgh Township. It has a water body setback of 15 meters. This is primarily related to the floodplain. So this is primarily to prohibit development in relation to a natural hazard rather than to promote conservation and preservation of natural heritage features. So this inconsistent approach is difficult throughout the city to implement, and it's generally inadequate when we look at our official plan policies. This represents a fairly significant area for improvement in the new zoning bylaw. Next slide, please. The first draft of the new zoning bylaw was released in 2016, and it sought to implement the official plan policies for natural heritage and environmental protection in 3 ways. The first was to introduce an environmental protection area zone, which prohibits most forms of development, and the boundary of this zone is based on the EPA boundary of the official plan. The difficulty with this approach is that the zone boundary is fixed, whereas the EPA designation in the official plan does allow for some degree of flexibility, specifically relating to riparian corridors. So the existing EPA zone approach is not implementing the intent of the official plan to the fullest degree. The second approach is to bring in water body setbacks. Generally, it's a 30-meter water body setback that's being recommended in the new zoning bylaw, with a 10-meter water body setback only within the downtown core in particular. So it's 30 meters throughout the municipality with 10 meters right downtown. This water body setback is a text-based regulation, so it does not need to be mapped, which is a very efficient way to offer protection. You define a feature, and wherever that feature happens to be found, the municipality is able to offer protection for it. The third approach was a natural heritage overlay, and this was a map that was prepared that included all natural heritage A and B features together with their adjacent lands, and prohibited development within these lands unless that development was supported by an environmental impact assessment. Although this approach would provide a strong level of protection for our natural heritage features, it was determined that this approach is conditional zoning under the Planning Act, and unfortunately, municipalities don't have the ability to implement conditional zoning at this point in time. So the natural heritage overlay approach to providing protection specifically to heritage B features and adjacent lands needs to be rethought in the second draft. We heard from members of the public on the first draft, and if we can move to the next slide, the majority of the comments related to the proposed EPA zone boundary. And so there's a few slides here that have the existing zoning shown in red and the proposed zoning overlaid on top in blue. And the concerns primarily related to the boundary of the EPA zone, mainly in relation to residential properties. So the EPA zone was coming in and transitioning residentially developed properties from a residential zone to an EPA zone that prohibits development. And if we can move to the next slide. This is another example. This is a portion of Highgate Creek. These are obviously residential plans of subdivision with residential zoning. And the first draft of the new zoning bylaw was proposing to rezone dozens of properties to be non-conforming uses. And next slide. This is a third example from the East End. This time, this is the neighborhood of Treasure Island. Again, a residential plan of subdivision with the first draft of the zoning bylaw coming in and proposing to rezone dozens of properties from residential to EPA, which prohibits residential uses. So this approach of rezoning existing developed lands to create non-conforming uses creates a problematic planning approach where any small addition that may be appropriate for these existing structures, or a deck, small shed, etc., would require complicated planning approvals. And further, if financial lending institutions take issue with the fact that the use is located in a zone that does not permit that use, it may complicate the purchase and sale of these homes, which was not an intended focus of the first draft of the zoning bylaw. So we decided that we needed to take a look at this approach. And if we can move to the next slide, please. We found that there were 5 other implementation issues that we needed to put further effort into exploring. We're going to go through each of these 5 issues in greater detail in the coming slides. And as we were researching these issues, we looked to 9 other comparison municipalities to see how they were tackling it and what we could learn from their existing approaches. These 9 municipalities are a combination of our neighboring municipalities together with other municipalities within the region. Next slide, please. The first topic is a fairly big one. And what we really wanted to know was whether or not other municipalities were including riparian corridors, so the lands within close proximity to water bodies and wetlands, whether or not other municipalities were including those riparian corridors and ribbon of life areas within a land use designation, such as an EPA designation, as the official plan designations form the basis for zone boundaries in the implementing zoning bylaws. And what we found was that most municipalities are not including riparian corridors within the EPA designation, and that most municipalities are protecting these environmentally sensitive features through a text-based policy rather than a mapped-based approach. The benefit of a text-based policy is that wherever a defined feature happens to be found in a landscape, a municipality has the tools it needs to be able to protect it, rather than requiring that feature to be drawn on a map in order to protect it. And so our recommendation is to transition riparian corridors from a natural heritage A feature and the EPA designation and move them to a natural heritage B feature. And as part of this approach, we'd like to strengthen the wording in section 3.9, the ribbon of life section of the official plan, and clarify that riparian corridors, ribbon of life, 30-meter water body setbacks, they are all intended to be text-based, and that we do not need to be showing those features on any of our schedules in order to offer protection to those features. If we can move to the next slide, please. This is a map that shows lands that are currently designated environmental protection area in the official plan now. This is a portion of the municipality. So everything shown in green is EPA today. And what we're proposing to do is to shrink that EPA designation boundary by the width of riparian corridors in favor of strengthening the wording in section 3.9 to clarify that riparian corridors and water body setbacks, ribbon of life, they don't need to be shown on a map in order to be protected. We know that riparian corridors along water courses, we don't have them all mapped. We're missing quite a few. We don't know how many, but we know that we are missing them. And when we are trying to protect them on a map, if we do not have them mapped, it becomes problematic. So if we change to a text-based approach, we will be able to pick up the protection for those features wherever they happen to be found on the landscape. Next slide, please. This approach of transitioning from a mapped-based to a text-based regulation would then help the implementation of the EPA zone boundary within the new zoning bylaw by allowing the EPA zone to also exclude riparian corridors in favor of the general 30-meter water body setback that would be already applied as a text-based regulation in the zoning bylaw. So what we have here is an example of one of the areas where we heard from residents on the first draft of the new zoning bylaw, which is shown on the left. And it shows the EPA zone boundary coming in. And with our proposed official plan amendments, it would allow the zone boundary to be pulled back to maintain the residential zoning on properties such as this, while still maintaining a 30-meter development setback for any future development. Next slide, please. We worked with our colleagues in GIS to get a better understanding of how many properties were actually affected by this proposed mapping change. And what we found was that it's about 4,200 properties that would be impacted by this mapping change. It's relatively evenly split between the urban area of the municipality and the rural area of the municipality. And of those 4,200 properties, there's approximately 1,900 structures that would be directly impacted by this mapping change. So if we maintain the approach that was in the first draft, there would be approximately 1,900 structures that would be located within an EPA zone when we're already protecting those same lands through a general 30-meter water body setback. Next slide, please. The second topic that we started to research into was the actual definition of water body itself. And so what we wanted to know is what other municipalities, how they're defining water bodies and what they're actually protecting, what features they're protecting, what features they're not protecting. And what we found through our municipal comparison was that there's a wide variety of definitions for water bodies and water courses. And that some municipalities define more natural features or make reference to natural features and to try and clarify what they are intending to regulate. And so our recommendation is to replace the definition of water body in the second draft of the new zoning bylaw with the below wording, which tries to emphasize the natural aspects we'd like to protect, pond, wetland, river, watercourse, while specifically excluding or making reference to the features that we don't want to regulate, such as artificially constructed swales and ditches intended for intermittent and minor surface drainage of residential lots. Next slide, please. Third topic that we explored was water body setbacks themselves and whether or not different water body setbacks should be applied in different contexts within a municipality. And what we found through our municipal comparison was that it's generally a 30-meter water body setback through and through. It's quite common. But there were examples where reduced setbacks were implemented in highly urbanized, highly urbanized municipalities to reflect historical parcel fabric, existing development trends, filled lands, hardened shorelines, etc. And that some municipalities included exemptions for minor residential accessory structures, such as a small accessory shed or some stairs going down an embankment towards the water. And so our recommendation is to carry forward the general 30-meter water body setback that was in the first draft, and also to carry forward the reduced 10-meter water body setback that would apply just in the downtown core itself. So carry those two setbacks forward into the second draft. The 10-meter water body setback is proposed for the shoreline area, generally from Doug Fleur Park along the shore of Lake Ontario to Ontario, where it turns up into West Street, that portion of the municipality only, which is the portion of the municipality regulated by Zoning Bylaw 96259, which has a 10-meter water body setback in place today. We're also proposing to bring in an exemption for up to one residential accessory structure, so something under 10 square meters. So if it doesn't require a building permit, then consideration for that within the water body setback. It could be located in accordance with our standard residential accessory structure setbacks. Next slide, please. The fourth topic relates to the natural heritage overlay that I discussed earlier that we determined was conditional zoning, and we were not permitted to take this approach at this point in time. And when we went through our municipal comparisons, we found that the majority of natural heritage B features and adjacent lands are not being included in zoning bylaws, so not being protected by a zoning bylaw. What we did find was that some municipalities are starting to use site plan control to offer protection to these natural heritage B features and the adjacent lands. And we are recommending that consideration be given to revising the site plan control bylaw to include natural heritage A and B features and the adjacent lands. But we need to recognize that there's going to be lots of areas where, especially adjacent lands, where proposed development is not going to have an impact on the actual natural heritage feature itself. So perhaps it's development within 120 meters of provincially significant wetlands, but there's a fairly major road intervening between the development site and the wetland itself. That development is likely not going to have an impact on that wetland. So there would be less of a reason to go through site plan control. So in order to bring in that level of flexibility, we're suggesting that the applicability of site plan control be subject to the director discretion or discretion of the director. Next slide, please. This slide summarizes our natural heritage features with the middle column indicating whether or not that natural heritage feature would be protected by a zoning bylaw or not. So the first 5 or 6 there, those are our natural heritage A features, and those are the features that would be brought into our EPA zone, and they would be protected. Riparian corridors would also be protected. We're recommending that they be protected through a 30-meter text-based policy and regulation in the zoning bylaw. But the bottom half of this table, those are our natural heritage B features and the adjacent lands to those features, and they wouldn't be protected through the zoning bylaw. The natural heritage overlay approach that was proposed in the first draft, it was trying to offer protection to these features in accordance with our existing official plan policies. Since that approach is not feasible, we have determined that we could use site plan control to fill that gap and to offer protection to those features where needed. Next slide, please. And the last topic that we explored was mapping accuracies. And so it was the effectiveness of mapped EPA zones or EPA designations, and realizing that the effectiveness of these mapped approaches is directly related to the accuracy of our mapping. And through our review, we were fairly confident in the mapped boundaries of most of our natural heritage features. But we realized that riparian corridors, because we don't have so many of the smaller water courses and the headwater features mapped, we're not protecting those riparian corridors to the fullest degree with the existing mapped approach. So we're recommending that the riparian corridors and the protection for riparian corridors be transitioned from a mapped-based approach to the text-based approach, which would then allow us to better protect those features. Wherever they happen to be found in the landscape, we would have the tools to protect them. Also, we're going to be working with the Ministry of Natural Resources to ask them to amend boundaries to a few provincially significant wetland complexes and perhaps an ANSI boundary to better reflect the actual boundary of the natural heritage feature itself. There seems to be a discrepancy between the mapping and aerial imagery for the feature. Our conversation with MNRF thus far have been supportive, and it looks like we're going to be able to get some of these mapping changes brought in to make sure that our mapping is as accurate as possible. Next slide, please. So recognizing that I've been speaking for a while, I hope everyone is still with me here. This slide summarizes our proposed approach. It starts with amendments to the official plan to transition those riparian corridors from a mapped-based approach to a text-based approach. So moving from natural heritage A and the EPA designation to a natural heritage B feature, and really strengthening the wording in section 3.9, our ribbon of life section, to clarify that we don't need to map them, we just need to describe them, define them, and wherever we find them, we'll have the tools to protect them. This change from map to text approach would then allow in our new zoning bylaw us to update the EPA zone boundary to better reflect the EPA designation and to better reflect the existing uses that are in play today. We'd like to maintain the 30-meter general water body setback, this being 10 meters through just the downtown core itself. Update the definition of water body to better clarify what we intend to protect through the 30-meter development setback and what we don't intend to protect. And bring in an exemption for up to one accessory residential structure up to 10 square meters to be permitted within the water body setback. We're also recommending that the site plan control bylaw be updated to offer protection specifically for the natural heritage B features and the adjacent lands, but to bring in a mechanism to allow staff to review those applications and to not make people go through site plan control where that exercise would be onerous. This review process, I think, we need to work out the details on how that would function, but certainly it would require some consultation with our colleagues at Catawaka Region Conservation Authority and in looking at our official plan policies. And the last point I'd like to make is that our site plan control bylaw is slated for a general update later on this year. And so the implementation details of this site plan control approach would need to be developed in consultation with that broader review, which of course would include extensive public consultation. And with that, it is the conclusion of my presentation, and I am happy to get into the questions and comments here.
Great. Thank you very much for your presentation. I believe we'll go into committee first, and then we open it up to the public. We are doing each of these distinctly, I believe. Good. So I'll open the floor to members of the committee. If you have questions, just raise your hand and I'll recognize you. Yes, Councillor Hill.
Thank you, and through the chair, I just have a couple questions. So properties then that are currently, in existence and where the property is developed, basically up to the shoreline. So I'm lakeside, and so there'd be a number of properties in Redendale and Sunny Acres, etc., that are in that situation, right? So by eliminating the mapping, are we saying that effectively sort of whatever is there now is all that has to be kind of protected? Like, would they be able to build a pool in their backyard if they don't have one now, that sort of thing?
The zoning bylaw doesn't regulate pools, but what this proposed approach would do would be to, if it's a residential use and it's a residential zone now, it would maintain the residential zoning. So we wouldn't be establishing a legal non-conforming situation. Any future structures, if that dwelling is developed at 15 meters from the high water mark for discussion's sake, they wouldn't be able to go any closer to the water. They wouldn't be allowed to build a deck or a shed or something between their house and the water now. They would be required to maintain that 30-meter development setback that would be established by the zoning bylaw. If they wanted to put on a small addition or something onto the side of their house that wasn't going any closer to the water body setback, that would require a minor variance in order to do that. And there is exemptions within our existing official plan policies now that would give consideration to that. It would allow staff to consider minor variances for appropriate development of existing lots where there's existing homes.
So through you, Chair, so if you because a lot of the houses right now wouldn't be any more than 15 meters probably from the shoreline or from the high water mark. So if they wanted to put an addition on the back of the house, they couldn't do that then.
Through you, Mr. Chair, that being the back of the house being closest to the water then?
Closer to the water.
Yes, that's correct. So with the new zoning coming, that is being proposed, the 30-meter setback would apply to any new development. And so 30-meter setbacks, if they can't meet a 30-meter setback, they wouldn't generally be permitted to go any closer to the water body, but lateral additions that maintained an existing setback could be considered. There's existing official plan policies in place for that.
So, and then legal non-conforming, does that afford the homeowners more protections than this, or less, or is it the same? I'm just trying to make sure that, you know, we're not asking homeowners to kind of give up some of the protections that they currently have.
Answer that through you, Mr. Chair. So when we talk about legal non-conforming in the new zoning bylaw, there are really two areas of legal non-conformity. So there's legal non-conforming uses, and then there are legal non-complying buildings. So when we're talking about the amendments that we're proposing to make to the second draft, it's to ensure that the uses are permitted on that property in the zone. The buildings themselves would become legal non-complying in the new zoning bylaw because there are performance standards for those buildings that aren't being met. So the setback from the water would be a situation where the building itself is legal non-complying, but the use is permitted. So there will be some permissions in the new zoning bylaw related to legal non-complying buildings, but there are no expansion permissions related to legal non-conforming uses. So for a legal non-conforming use, it needs to go through a Planning Act application. For a legal non-complying building, they would be permitted to build in an area on that lot that complied with the zoning bylaw 100%. So say they wanted to put an addition on the front yard, if they met the front yard setback and the rear yard setback and all of the other performance standards, they would be allowed to do that. But where they're already deficient in a setback from a water body, they wouldn't be able to do that as of right without going through a Planning Act application. The difference in the amendments that we're talking about today is that based on the first draft, those structures would have been in an EPA zone. Therefore, if they wanted to do anything to those properties, they may have been required to go through an official plan amendment. They would have been required to go through a rezoning application. And even then, it would be a very complex Planning Act process, whereas the amendments that we're proposing to make would establish those underlying use permissions and enable a framework that we could properly consider these through a more appropriate Planning Act process, which might be a minor variance application if they meet the requirements of the official plan.
So may I continue, Chair?
Please do.
Now if someone were to come in and take a current structure down in order to build a new one, and that's happened a lot in this area, presumably they could not build that anywhere closer than the 30-meter ribbon of life. Is that correct?
Through you, Mr. Chair, I think if the answer is kind of a non-helpful, it depends. And it depends on the size of the parcel. Our official plan does have existing wording in there for development of existing lots. This is in section 396. And so if the parcel is not physically large enough to locate development outside that 30-meter water body setback, then an appropriate amount of development can occur on that property while trying to maintain the greatest water body setback that it can in a redevelopment scenario.
So in effect, having to sort of build on the footprint?
If that's the case of a particular parcel, if it can't move any further forward, then it could maintain that existing setback, I would think.
So I'm sorry, just as a follow-up, in the past, we've approved totally demolished existing non-conforming use as long as they built within the footprint that existed. Now they could go taller, they could gain that way, but they had to be on the existing footprint. Is that going to change? I think that. is part of what Councillor Hill was looking for, if I'm not mistaken.
Through you, Mr. Chair. So if someone wants to demolish and rebuild the exact same house in the exact same footprint, they have permitted, like they have legal non-conforming right permissions under the Planning Act to do that. So they have the ability to demolish an existing building and build the exact same building in the same place. I think we would have to speak with our legal services department about an expansion of that building. If it's an increase in height with the same footprint, I believe that they would require expansion application through the Committee of Adjustment. So it's the expansion of a legal non-conforming use, and that would need to go through the Committee of Adjustment, and it's subject to different tests than a minor variance under the Planning Act. And
I have one last question. And I had this question came from a number of my residents, but is that they currently have to go through both the city and the Cataraqui Region Conservation Authority in order to get approvals. And so the general, I guess, sentiment was, why would we have sort of a layer of city zoning on top of, and I'm talking in terms of the ribbon of life, on top of the Conservation Authority, if the Conservation Authority, in fact, has primary responsibility for that? You heard that, I can tell by your smile. Go ahead.
Sorry, through you, Mr. Chair. I'm not sure who's smiling, but
it was Laura that I saw smiling. But
okay.
Go ahead, Niall.
So I think that's a really interesting question, and it's something that I have a question that I've fielded many times in my planning career thus far. So the conservation authorities, they issue development permits under the Conservation Authorities Act, under Section 28 of the Conservation Authorities Act, and that is in relation to natural hazards primarily. So the protection of floodplain and making sure that development is safe from a hazards perspective. Whereas the municipal zoning bylaw is maybe also trying to achieve those same levels of safety perspectives, but are going beyond that and have a larger mandate to also be looking at like open space on properties in some instances, and maintaining the natural heritage features, providing opportunities for habitat enhancements and those types of things. Certainly conservation authorities have interest in those as well, but the permits that are required before a property owner can get a building permit, for example, are in relation to the natural hazards, be floodplain and wave uprush and those types of things. So I can appreciate from a property owner perspective, it may be seen as a bit of a duplication of effort or red tape, perhaps having to get multiple levels of approval, but they are focused on different aspects of ensuring appropriate development.
And I think that would be important to make sure that that's well explained as we go forward. Thank you.
Thank you very much. And I know that there were a couple of other councillors that were putting questions forward through the week. So, and I want to, I'll recognize Councillor Zanuck, but I want to recognize and welcome Vice Chair Kiley back to what we have of the horseshoe. So go ahead, Councillor Zanuck.
Thank you very much, Mr. Chair. Through you, 2 questions to staff. So when we just said that it reverts back to, it maintains the residential zone, does that mean that the homes that were originally affected, like they do go back to being R1 zoning if they were R1 zoning beforehand?
Through you, Mr. Chair. Sorry, now you can go ahead on that one.
Through you, Mr. Chair, that is the intent wherever possible, especially within lands that have been developed through a previous plan of subdivision where the zone boundary was established based on a Planning Act application, and the intent of the land was to have residential uses. The intent certainly would be to maintain that moving forward.
Okay, great. So then, like if I could use Safari Drive, right, as an example. So they were definitely one of the part of Safari Drive, right, was affected by this new mapping. Now we're not going to use the new mapping, and they're going to revert back to an R1 residential zone then. Yep. That's a specific question I got going into tonight's meeting.
Through you, Mr. Chair, that is the intent. Specifically on Safari Drive, what we found when we started to really analyze that proposed EPA zone boundary in the first draft was that zone boundary was based on the EPA designation boundary, which was based on provincially significant mapping, the provincially significant wetland mapping, and then the Riparian Corridor 30-meter buffer on top of that PSW mapping. And when we got looking at the PSW mapping and then looking at aerial imagery, it seems that the PSW mapping is drawn in error in that particular location. It comes inland much farther than it ought to based on the aerial imagery. And so that is one of the areas they've looked at the mapping, they agree that there's a problem with it, and they've agreed that they're going to pull that mapping back. So the Safari Drive property with this proposed approach would then maintain that residential zone boundary on the particular parcels themselves, with the EPA zone boundary anticipated to start at generally the rear lot line.
Okay, so that's great. So then in part 2 of the question that was sent to me tonight is if the setback stays at 30 meters, that results in our homes being totally, you know, and all utilities within that setback. So I just heard that basically then the 30-meter setback is at their rear lot line. Is that what I just heard, Mr. Odie?
Through you, Mr. Chair, the 30-meter setback would then start at the rear lot line, wherever the EPA zone got pulled back to on those properties.
Okay.
That is where the 30-meter water body setback would commence. So depending on the depth of those lots, the homes may still fall within 30 meters of water body setback, which would mean that they wouldn't be able to put any rear additions onto those particular houses. Similar situation as Councillor Hill was describing earlier. But what it would mean is that their property would be zoned residential. It would be in a residential zone. They would be a legal permitted use. Any future addition into the rear yard would require Planning Act approvals, and they wouldn't be able to do that as of right. But they wouldn't be hindered by those potential mortgaging financing issues with legal non-conforming status.
Okay, thank you. So if their other concern also is this could have a significant impact on property values, that wouldn't apply because the R1 zone goes back to their house. Is that right? Except they still might be confined if somebody wants to buy the house to tear it down to create a big monster home, then that's where they're going to be confined, like we just had the conversation over the existing footprint.
Through you, Mr. Chair, I think that's correct. The intent is to maintain the residential boundary of those lots in a residential zone. Any potential future development would need to comply with the regulations of the zoning bylaw. And if any Planning Act applications were to be required, then the policies the policies of the official plan would kick in at that point.
Okay. Okay, great. Thank you.
Thank you very much. Any further questions? Yes, Councillor Kiley.
Thank you, Mr. Chair, and it's good to be back. I'm wondering if staff could talk a bit about the 10-meter setback that's proposed for the downtown central business district and harbors. If you could give a bit of the rationale to the public about why that's a different setback distance than what we've been talking about residentially with 30 meters.
Through you, Mr. Chair, I think that's an excellent question. It's the existing zoning that's in place now in Zoning Bylaw 96-259 for the downtown and harbor zoning bylaw. It has a 10-meter development setback applied to the downtown zone or the central downtown zone. I forget the particular term right now in the harbor. areas, so the waterfront areas. And that is to recognize the existing developed nature of those areas, the highly urbanized nature of those parcels, the existing parcel sizes, the fact that a lot of those lands have been filled, they've been previously developed, and they're not in a very natural state right now. In fact, some of those lands may not even be natural lands at all. They may just be filled lands in former Lake Ontario. So a 10-meter development setback was brought into 96-259, and that is primarily, I understand, to implement or provide an opportunity and requirement for the Waterfront Pathway, Waterfront Pathway, sorry, which is required by our official plan. So it's a 10-meter development setback, and the zoning bylaw then also requires a 10-meter pathway to be installed for public infrastructure and recreation purposes. So recognizing that reduced setback has been in place within the central downtown area for a number of years, and perhaps some development concepts have been prepared based on that existing setback, and there are a number of constraints for those parcels. We elected to carry forward that 10-meter setback into the first draft of the zoning bylaw, and through this work, in the contemplation of the second draft, we found that other municipalities do have reduced water body setbacks within their highly urbanized areas as well, recognizing that these areas don't carry the same ecological significance as the more natural areas do. But still, that reduced setback still provides an opportunity for the waterfront pathway to be implemented.
Thank you, that's helpful. I'm wondering if that 10 meters could be changed based on a given site. So I think, for example, the tannery lands, where perhaps public interest and perhaps even the proponent have talked about naturalizing or keeping somewhat wild shoreline. Presumably, if that's driven by the proponent, they could go beyond that. So even though it's as of right, they could go further back. That's just up to them to make that decision.
Through you, Mr. Chair, the reduced 10-meter setback does not apply that far north into the inner harbor. It doesn't have a very well-defined boundary in the first draft right now. It kind of ends, I'll just say generally, the land south of Doug Fleur Park, and then in and around the shoreline around to where Ontario Street bends up to West Street. So those are the areas that have a reduced 10-meter zoning setback in place now, which is the same 10-meter setback that is being proposed in the new zoning bylaw.
Okay, that's actually helpful to know. Thank you. My second question, or second line of questioning, I suppose, is about director's discretion. I noticed that one of the clauses in the report talked about replacing existing exemptions in section 3 to allow the director to exercise discretion. Could you give us a bigger context of that and tell us why that's recommended?
That director, sorry, through you, Mr. Chair, that director discretion is recommended as a means to allow staff the opportunity to use site plan control as a tool in the areas where it would be useful to do so. So if we're dealing with some type of natural, say a provincially significant wetland in a rural context where everything's in a fairly naturalized state, someone's proposing development in proximity to that provincially significant wetland, we could use site plan control to require a environmental impact assessment to be done to look at the land, to look at the development proposal, to provide mitigation measures, establish a development envelope in an appropriate area of that property, and then use the site plan mechanism, register an agreement, and make it legal to force the development to conform and to implement those mitigation measures. Without some type of, sorry, I'm getting to it. Without some type of discretion mechanism built into it, if we just said all development within 120 meters of a PSW or whatever natural heritage feature, it is going to encapsulate a vast number of parcels or a vast amount of land where proposed development would not impact that feature, whatever it happens to be. If there's an intervening road in the way, or perhaps there's an entire block of development between a proposed site and some significant woodlands or PSWs or something like that. So if there wasn't some type of director discretion mechanism built in, we would have to then require all sorts of properties to go through site plan where there would be no benefit in doing so. Now, perhaps as I mentioned, the site plan control bylaw is slated for a general update later on this year. So perhaps through that work, we can look at better defining what forms of development or qualifying within the bylaw itself, that if there's intervening land uses that would signify that proposed development wouldn't have an impact on the natural heritage feature, that then those lands are not subject to going through the process. But what we didn't want to do was to make lands go through an onerous process unnecessarily when there was no benefit in doing so. But recognizing that it's a tool that we could use in certain situations to achieve mitigation measures and to force the recommendations of an environmental study to be implemented.
Okay, that's helpful. Thank you. And I was going to ask, I apologize for interrupting you there.
That's okay.
Doesn't impact council's or committee's ability to request a bump up, does it?
The existing site plan control bylaw has the ability for council to bump up applications that have been formally submitted. The exact implementation details of how this approach could be implemented through site plan, I think, would need to be further developed through the public consultation stage and the broader analysis of the site plan control update. So I think that's a very good question, but at this point, it's a concept that we're putting forth, recognizing that the existing natural heritage overlay is conditional and we can't use that. Laura, do you want to jump in?
Through you, Mr. Chair, yes. I'd just like to add, so obviously it's the proposed approach through site plan is something that would be subject to the future public consultation on the site plan bylaw. And certainly through that process, we can explore whether there are any type of bump up opportunities that could be built into that. So maybe when a building permit application is posted on Dash, if someone had an objection to the fact that they didn't go through site plan for that, perhaps there would be some type of bump up that we could build into that process. So that's certainly something that we can review through the future site plan bylaw review and make that kind of recommendation through that process.
Yeah, that'd be great. Let's just earmark that and look for it at another time then. Thanks.
Thank you. Councillor Hill, I think.
Yeah, sorry. Just I wanted Councillor Kiley's, or what I guess was one of Niall's responses, tweak this. And so through you, Chair, I don't imagine too much of the developed land outside of the downtown is going to be returned to its natural state. So assuming that, and in the interest of fairness, why would we not use the 10-meter ribbon of life and apply that to all areas that are currently developed? Now, I don't mean to areas that may be considered for future development, but for areas where that development already exists. It just seems to me in the interest of fairness that might be a bit more palatable to folks that live in those districts. Is there a particular rationale for that?
Yes. Mr. Odie or Ms. Flaherty to address that.
Through you, Mr. Chair. Sorry, I was having button clicking problems. I think that's a really interesting question, and I think that while lands wethin the urban area that, say like a lot of the examples tonight have been residential subdivisions backing onto creek corridors or wetlands, while they may not be returned to a naturalized state, I think portions of those lands are still going to play some degree of role, whether that's part of like a migration corridor for various forms of wildlife, or whether that's an opportunity for stormwater infiltration into, rear yard lawns, those types of things, which then helps with the base flows of creeks and wetlands. I still think that there would be a benefit in maintaining as great of a development setback as possible in relation to these areas. I think the part of the situation for downtown is that a lot of the lands that would be subject to that 10-meter reduced development setback, a lot of those lands are, I think, historically filled lands. They're lands that are fortified with reinforced concrete shorelines, and there's fairly limited opportunities to improve those areas to the same degree as a residential backyard would be.
Thank you. I believe Councillor Hutchison is the only person other than myself, and I have a couple of questions, but yes, Councillor Hutchison.
Hi. Sorry, I have a couple of questions there. A couple of them are close to what Councillor Carly was talking about, including the issue of the director's discretion when it comes to natural heritage features. I got the explanation. I just wanted to note that was of concern to me as well. Noted, okay? So the other thing is the whole issue of mapping versus texting. Maybe not texting, but text. And yeah, just send in your text and we'll change it. I wondered why I mean, there are advantages to both, it seems to me, but I think the text even says so. I was wondering why it didn't perhaps say something like both mapping and texting, because my main concern is with the protection of that 30-meter, okay, allowance. And would not be, say something like where it'll be mapped, but if the two are not consistent, then the text will obtain. I mean, I get the idea that maps are difficult to keep up and there's problems, and Mr. Odie said not everybody's maps agree, and I can see that. But I'm thinking that the text can be interpreted in various different ways that a map cannot, since it'll have coordinates and the like if it's done properly. So I was wondering why language like that wouldn't be incorporated. In the final analysis, it would be the text, but you want to look at the map and see where a property is at, and you'd be able to do that.
Yes, Mr. Odie.
Through you, Mr. Chair, I think that is a very good point, a very good comment, and certainly I think that is the approach that we'd like to take, which is the transition from like riparian corridors, for instance, from the natural heritage A feature, we transition into a natural heritage B feature. We're still going to show the riparian corridors that we do have mapped. We're still going to show them on Schedule 8 of the official plan. But then we would tweak the language within the actual plan in section 3.9 to say, basically, like, the ones that are shown on the Schedule 8 are the ones that we have mapped. Those are the ones that we know where they are. But where they happen to be found on the landscape that we don't have mapped, we don't need to go through an official plan amendment in order to offer protection to these lands. So I think that, like a hybrid approach is kind of what we're proposing here. But if it's not shown on a map, then it doesn't mean it doesn't get protected.
Right. Okay. So perhaps I'm not sure, but it sounds like I missed that you were doing a hybrid of some sort, at least in certain descriptions. Okay. Now, when we have a couple of situations where we wanted, well, I'll just say it, like at the current Davis Tannery, like we're a long way away there, but it was, and it's been changed since it was first presented. So you have the 30-meter riparian or corridor and the water body setback. They're both the same, according to what you said, and that sounds fine to me. But is it possible that if there are multiple conditions, like a significant woodland or EPA nearby, that 30 meters could be expanded under certain conditions? Obviously, there have to be limits. But...
Yes, Mr. Otte.
Through you, Mr. Chair, I don't want to get into commenting on this, like a specific active development file. I don't have the particulars on it, but in a hypothetical scenario, just because there's someone could meet a 30-meter development setback from the high water mark of whatever water body, doesn't mean that they would always be able to develop there. There are lots of situations where a water body coincides with the boundary of provincially significant wetland, in which case our official plan would be looking for 120 meters from the shoreline of that, or the boundary of that PSW. They might do an EIS or an EIA to justify a different development setback in there, but there are situations in which the 30-meter development setback from a high water mark could be increased based on the boundaries of any other natural heritage features that might be co-located.
Thank
you.
No, I just wanted to say that I didn't mean to. The reason I used the example I did, and I didn't really want to use a specific example, is because when it came back at certain places on the shoreline, it's back, I think, 45 meters or maybe 50 meters, right? So it was an example. I'm not saying that obtains, there's all kinds of things to be done with that, the planning for that property, and that's what suggested to me that perhaps those different considerations would come in confluence. So that actually is a possibility. I wonder if you could explain more detail what is meant by conditional zoning and how it isn't allowed when we're talking about the natural heritage overlay. Because it wasn't entirely clear to me. And I see
Ms. Flaherty had her hand up, I think.
She's also nodding.
Mr. Chair, so conditional zoning, so zoning bylaws are written in a way that is basically black and white. You are permitted to do this, you aren't permitted to do this. This is the minimum required setback, and it has definite numbers and provisions. Conditional zoning is when it says something along the lines of, you aren't permitted to do this unless you do an environmental impact assessment that demonstrates otherwise to the satisfaction of the city and the CRCA. So you're saying something is not permitted, but then you're adding a condition in there saying, but it might be permitted if you go through this process. So we don't have that ability within the Planning Act to actually craft a zoning bylaw that could be written in a conditional way to require something to demonstrate. So we have to write a zoning bylaw in a way that says, yes, you're permitted to do this. No, you're not permitted to do this. The minimum setback is 30 meters, and we can't require someone to go through an EIA through the zoning bylaw provisions. That would have to be done through the official plan policies and other policies, but it's not something that we could write into the zoning bylaw.
Thank you.
So would that be it sounds like maybe this is what you are doing. So you can't do the conditional. I understand what you're saying. You want, because clarity is needed. If it's under certain, okay, no. Why doesn't it just say, as perhaps you are, no, you can't be there. We're not setting conditions, we're just telling you. And for new development, I understand that already development in place is a different ballgame.
Who would like to answer
Is
that?
that saying that?
Through you, Mr. Chair, the reason that the zoning bylaw doesn't say you're prohibited from developing within 120 meters of provincially significant wetlands, or you're prohibited from developing within areas identified as significant woodlands, because that's not what our official plan says, to be clear. Our official plan says that development is prohibited within natural heritage A features, and that development is conditionally prohibited within the natural heritage B features and those adjacent lands. It's prohibited unless you do a study that demonstrates that it would not adversely affect those features. So our official plan is establishing some degree of, I suppose, development potential in those areas, provided that an appropriate study's been done and an assessment's been done, and it's not going to impact those features. So if the zoning bylaw came in and just outright prohibited all development within those areas, it wouldn't be in line with our official plan.
Okay, thank you.
Thank you. Vice Chair Kiley, could you take the?
I do, and I recognize.
Thank you. I'll try to whip right through these. I'm a little concerned about things that are now typically come to planning under a zoning and now they're going to be delegated to site plan. I know that we have bump ups. I can say every term of council, there's always one or two developments that I regret not asking for a bump up on. And so I'm just wondering how we can, and Ms. Flaherty mentioned this, how can we make sure that we aren't faced with what could be a faux pas and complaints from our constituents? How did you let this happen? So if there's some way of streamlining communication and site plan, since you're taking on more responsibilities, and that's a delegated authority. So I'd appreciate if there's a way that we can make sure that we don't have bump ups at every council meeting, which wouldn't be good for planning committee timing or others. So if you can address that, that's good. The 10 meter in recognition for the downtown, in automatic recognition that we have a 10 meter walkway provision that's always been there. But I can point out from 90s approvals where we weren't quite as stringent on that 10 meters as we should have been. What would be wrong with saying it's a 20 meter setback, including the walkway? And that way we're ensuring that walkways won't get ignored, waterfront walkways in the provisions for downtown. So that might be a way to ensure that, and which I think, and if in a future council wants to alter that, that's fine. They can face the electorate about cutting back on walkways. But the existing non-conforming uses, Councillor Hutchison will probably agree with this. It's a nightmare in the downtown because we've had so many zoning bylaws over the years, and we or our constituents have to end up being detectives to figure out that 40 years ago, when they had a double parking lot or they had a parking space in front, partially in front of their house, that was allowed in the zoning of the day. It isn't now. And it's such a nightmare to constituents. I see Councillor Hutchison smiling because he's probably faced some of these questions as well. So is there any way that we can take pictures or do something that will, as we do with heritage buildings, so that it isn't always at the discretion of constituents having to go to court to try to deny that or find that they indeed have an existing non-conforming use. So a catalog of existing non-conforming uses.
Ms. Flaherty, do you want to answer that or speak to that?
Yeah, please do, Ms. Flaherty.
Certainly through you, Mr. Chair. So the existing zoning bylaws, as something becomes legal non-conforming, a use becomes legal non-conforming, or a building becomes legal non-complying. Sorry, my dog's walking around in the background if you hear something walking around here. A building becomes legal non-complying if it legally existed in that location prior to the passage of the zoning bylaw. So right now it's a really difficult process to establish whether someone has a legal non-conforming use, simply based on the age of our zoning bylaws and the availability of information that we have from when those bylaws were passed. So when we pass a new zoning bylaw in 2022, when we have all sorts of technology available to us and we have the ability to schedule satellite imagery and additional data that we can then use as a reference point for when a new zoning bylaw is passed in 2022, we all of a sudden have a much better resource as staff and as members of the public to say, look, this bylaw was passed in 2022, and we can very, very clearly prove with pretty accurate information that this existed at that point in time. So the creation of a new zoning bylaw should actually help the process of determining whether outside physical structures and driveways and that type of thing legally existed. Obviously, when we're talking about the number of bedrooms or units in a building, it becomes much more difficult because we can't easily capture that data and secure that somewhere. Obviously, we have tax records and all sorts of things internally that we can review, but it's certainly that physical element that we can capture with newer technologies that should certainly benefit the process.
That's reassuring. Thank you. My final question, and this is a kind of a follow-up to Councillor Hill's concerns. With the new ribbon of light 30 meters being applied, is that for only structures that impede upon that? Will the people still be allowed to build a reasonably sized patio or a deck on their house, or would the measurement of the 30 meters be inclusive of addition decks or that?
To you, Mr. Chair, the zoning bylaw would not be regulating patios. Decks are structures under the zoning bylaw, so the 30-meter setback would be applied to a deck, and that is part of the reason why we were recommending an exemption for a small accessory residential structure. Whether that's a small garden shed in the backyard or something, or a small like 10 by 10 deck platform that if someone wanted to put that on a portion of their property close to, close to the water, wherever they like to sit on their property, and that happened to be within the 30-meter setback, then they could do that. I mean, realistically, I think people are going to do that anyways. If we don't allow a small exception like that, what sometimes does happen is people don't build those small decks, but they build a much larger patio, which we don't regulate under the zoning bylaw, which then introduces a whole lot more impervious surface and hardened, and it's much less natural than, you know, a deck sitting on top of the ground.
So something else for you to consider. And my very last question, I know from friends that I have visited over the years in Lakeside that some people have and have had for years docks, whether they're removable docks or more permanent structures. Are those going to be existing non-conforming use recognition, or will that be an allowance somehow?
Any takers on that one?
To you, Mr. Chair, I would have to consult the first draft of the zoning bylaw to see if docks were specifically identified as structures. To the best of my knowledge, I don't think that the zoning bylaw would be being applied to docks. I think we would leave that with Catawba Region Conservation Authority for appropriate shoreline permits and those types of things.
Okay. Yes.
And through you, Mr. Chair, I can just confirm that in the first draft of the new zoning bylaw and in the current draft of the second draft of the new zoning bylaw, there are exemptions for docks and other marine facilities along shorelines that wouldn't be required to comply.
Great.
I yield the chair to you, Councillor.
Thank you very much. I think we're now open to the public. Madam Clerk, I'm sure we have some people in a queue.
Thank you, Mr. Chair. We do have members of the public with us tonight, and we're just going to ask that they use the raise hand function, which is located in the center of your screen in Zoom when you move your mouse over top of it. Mr. Chair, we do have Ms. Farrar who would like to speak first. And Mr. Chair, before perhaps I ask Ms. Farrar to unmute herself, if you'd like to go over the rules for public speaking at
Sure.
the meetings.
Happy to. You need to give your name and address at the very beginning, and you have a 5-minute opportunity to speak. All of the questions are gathered, and then our planners will have an opportunity to answer them afterwards. If there's a whole slew of them, we sometimes stop after 5 or 6 questions and then go back afterwards. Did I leave anything out, Madam Clerk?
I don't believe so, Mr. Chair.
Thank you.
Okay, so I guess I'm on. Can you hear me?
We can indeed.
Okay, so it's Mary Farrar and I live at 83 1 Plus Darm in Kingston. I have 3 short questions. First of all, thank you for doing this. It's so long overdue, and it's wonderful to have the coordination and coming together. I think it's really helpful. So my first question is about, and I haven't had much time to look at this, so it may be not appropriate, but it only talks about fish habitat. What about turtles? What about amphibians and reptiles? What about small mammals? What about birds and migratory birds? I mean, I don't know why no mention was made of that when it talks about fish habitat. So that's question 1. Question 2, a short one. I'm wondering if the Rideau Corridor landscape strategy has any bearing on any of this, or if that was a part of the consultation. And question 3 is about the tannery. And I know I shouldn't be addressing something specifically, but I'm sort of confused about the 30-meter setback. So if a property owner owns a property, does he own the 30-meter setback? And then the question to the tannery, but maybe to other properties as well, is about the trail. So if there's a waterfront trail going along, does it go behind the 30-meter setback to be another kind of 3 meters of trail? Or like, that's what my preference would be, as opposed to Councillor Neal, who might like to have it included. So those are my three concerns.
Thank you.
Okay.
Who's next, Madam Clerk?
Mr. Chair, I'm not seeing any hand. Oh, there's a couple hands right there. Perfect. So I'm going to ask Mr. Hargreaves if he would like to unmute himself, please.
Good evening. My name's Chris Hargreaves. I'm the chair of the Kingston Field Naturalists Conservation Committee, and I have spoken at Planning Committee several times in the past, generally opposing any increment on reduction of the environmental protection areas. So this proposal is of great interest to the Kingston Field Naturalists, and I would like to commend staff who reached out to us, and Ms. Flaherty and Mr. Odie gave me a briefing as to what was proposed before this meeting. And I do appreciate the problems which would arise if a whole lot of current residential properties suddenly became designated as environmental protection area. And so I would just like to, I had a number of questions very similar to those which some of the councillors have raised, so I won't repeat them all, but just say subject to the same sort of questions that councillors had. I and the KFM would support these changes, even though there's a reduction in the EPAs. We understand why, and we are going along with the draft. And so thank you to staff. Thank you to Planning Committee.
All right, Mr. Chair, the next on my list is Ms. Schmolka. I will ask her if she could unmute herself, please.
Thank you very much. Can everyone hear me? Great, thank you. Good evening, everyone. I don't share Mr. Hargreaves' optimism about this proposal. I'd like to start by saying I think that we can all agree that without water, we are all dead. Water is the essence of life, and we realize more and more the importance of protecting our water sources, both from a drinking perspective for all of us, but also the hazards that water can create, and that the whole reasoning, and Mr. Odie did allude to this, the whole reason for having an EPA area and riparian zones is to protect natural life, but also human life and human property. So I'm very concerned that we haven't really looked at this the way we need to. I would like to point out that the new provincial policy statement, the 2021, has the words climate change in it 20 times or 19 times, and there's a reason for that. We're just very much more aware of the consequences of extreme rain events, all the ways in which our climate is changing in a way that can be detrimental to all of us. I think people who live by water have a special responsibility, and it's a community-wide responsibility. And I appreciate that people who live in buildings that are too close to the water, and I'm probably one of them, just moved into places that were built that planning committees like yours approved in the past, and that has resulted in people living close to the water. But I think it is a big mistake to think that that gives us a privilege. I think it means that there are more complex planning rules that have to be applied, but I don't think it means that we're somehow granted some grandfathered permission to do things that we know are no longer acceptable. And my analogy for this is you wouldn't want heart surgery based on 1960s technology. You don't want to abuse water, your proximity to water based on something that happened many, many years ago. I mean, Bell Park was a city dump until the 1970s. We would never do that again. So I think we have to look at this in a whole different perspective. And I think one of the things that troubles me with all of this changing, like Councillor Osanek asked, that all those places on Savary Drive will become R2. Well, that tells them that they're not living somewhere special. That by removing the EPA behind their houses, you're sort of saying to them, you can do whatever you want. And I don't think that that is the right way to approach water protection in the 21st century. I really am disappointed that staff looked to Gananoque and South Frontenac and Loyalist Township to compare. Those are not, with no offense to our neighbors, those are not the places of best practices in water protection. Look to the regional municipality of Waterloo or Aurelia or some of the other municipalities who've taken some innovative and progressive approaches to protecting the land along water. And don't tell me what South Frontenac is doing. I'm sorry, it's not our comparator. The city wants to stand out as a city of sustainability. So let's look at the better places, not the others. And I'm not necessarily naming the absolute best places. I think another real disappointment for me in this policy, and I should have said I'm speaking personally, I wear many different hats. I didn't have time to get a group, to talk to everybody and get permission to speak on their behalf. So I'm speaking on my own. But this policy seems to be looking at the existing developments and new developments and lumping them all in the same pot. Well, I don't think that's appropriate. I think existing developments, yes, we have to think through how to not make those properties difficult. And I'm wondering if anyone ever received proof that it would be difficult to sell your house or get a mortgage on your house because of the zoning on it. I'm not sure that's a fear, but is it a fact? And I would like to hear from bankers to say, yes, it's a fact. But I think I lost my train of thought there. Looking at Safari Drive, it's one thing that people that live on Safari Drive, what about the development that's possible across the creek there? What is the new permission there? It's outside the urban boundary right now. And my point is, it should have more stringent protections for the water system. Okay, Safari Drive was allowed to build the way it was, but on the other side of the creek, let's not let that happen again. Let's make sure the setbacks are strict and strong. And I don't see this policy doing that. I share Councillor Hutchison's concern about Director and Councillor Kiley's concern about discretion. We don't have a lot of confidence in that discretion, and this is moving the whole process to privatize it. We've privatized our waterfront in the past. Now we're privatizing the process to allow approvals to things that can happen near the waterfront. The idea of the 10 by 10 structure, well, that structure doesn't exist by itself. That structure includes a pathway to get to that structure. Someone's going to store their lawnmowers there, their pool equipment, whatever, and have a patio there too. I'm not sure this 10 by 10 structure idea is really feasible. I also worry about site plan being the appropriate way to manage all this. I'm just very conscious of time. And with respect to conditional zoning, yes, zoning, it's not allowed, but we certainly have conditions in our official plan. We have a 25.5 meter height limit in downtown, pending our urban design study that says you can go higher. So we could have official plan policies that say 30-meter rigid, text-based, you cannot move further, you cannot move anything into this area unless you have a study to show it. And again, there's that distinction between existing and new.
About 20 seconds, please.
Thank you very much. I'll just have a quick look at my notes. I found the staff report very complicated to understand what it is that is really going to happen. Like, how is it going to work on the ground? And I think it's really important for planning committee to ask staff to tell them exactly what this means, not what word is going to change in the official plan. Like moving riparian corridors out of the official plan, natural list A, is really troublesome to me because I appreciate there might have been implementation problems, but I'm not sure
Thank you very much.
Could you send
share your notes with the clerk so that anything that you missed we can read?
I will undertake to write to the committee. I don't think my notes are what it's going to be, though. Thank
Whatever.
you.
Thank
you very much.
So, anybody else? Elizabeth.
Thank you, Mr. Chair. I'm just going to ask if perhaps we could do a final call. I don't see any hands currently, but if we could do a final call, should there be anyone else who wishes to speak at this time about this public meeting, if you'd please raise your hand in Zoom. And we do have another hand, Mr. Chair. I'm going to ask if Leslie Rudy would please unmute.
Hi, thank you, everybody. I just, I guess I'm echoing some of the concerns about the discretion of the director, and I think I'm going to just ask, because it's not clear to me as a non-planning person what site plan control is and how that is different from what is in the zoning bylaw. So if maybe I could have a quick explanation of that, or if there's somewhere that somebody can direct me to look that up, or if that could be more clear in the document so that it's easier to parcel out what that means for us non-planning people. That would be really great. But it sounds to me that that we're going to have rules, but somebody can say, oh no, we're not going to follow those rules. And that's concerning to me. Thank you.
Thank you. And Ms. Flaherty will address that, I'm sure, at the end of all the questions. And I see Mike Dakin has his hand up.
Thank you, through you, Mr. Chair. First of all, I have to say thank you to staff for involving conservation, Cataraqui conservation staff from the onset. We've been involved from very early on, previous iterations of the zoning bylaw, and we're quite pleased with the approach that's been taken. We've reviewed extensively with Niall and Laura to try to make this the best approach moving forward. And there's a lot of details that do still need to be ironed out, but I think a point that has to be kept in mind is specific to riparian areas. The protections are essentially the same as what was there previously through the official plan and moving forward. They are essentially the same. What the difference is that the changes will not place legal non-conforming status on properties that should not be legal non-conforming. Yet at the same time, through the text-based approach, the riparian buffer will be protected. The 30 meters is and I know there's some reluctance to compare to other municipalities, but those other municipalities are quite progressive, and they've had a 30-meter minimum setback for years. City of Kingston has been behind, and the official plan is quite progressive, but the zoning bylaw, as you all know, is quite outdated. So I think it needs to be kept in mind that 30 meters is I wouldn't say the industry accepted, it's the scientifically accepted minimum, and that's where we commend the city with finally adopting that as the setback. And again, reiterate, and I think Niall had said this too, that 30 meters is a minimum, and in many cases a greater setback will be required because of other sensitivities on certain properties. Mrs. Schmokel spoke to the Collins Creek area. Any development on that western block would be significantly further from Collins Creek than the development on the east side, and that's because we protect things like floodplains and wetlands now where they weren't in the past. So anyways, I just wanted to share the Conservation Authority's support, and again, being grateful for the work that staff have done, and we do think that this is the right approach. Thank you.
Thank you, Mr. Dakin. Any further hands up?
Thank you, Mr. Chair. At this time, there are no further hands. Perhaps staff can start addressing some of the questions at this time.
That would be great. So the floor is yours to the staff.
Through you, Mr. Chair, I suppose I'll just start at the top here with Ms. Farrar's comments. There's a comment about turtles and what about other species? Fish habitat is listed, but not other species. And I think that that's a really interesting point. Our official plan does identify fish habitat. I don't have a firm answer for you this evening on why exactly fish habitat is identified, but fish habitat is essentially water bodies, and the Natural Heritage Resource Manual gets into kind of specifying that and providing clarity on that. Our official plan certainly does contemplate habitat for other species and species at risk, endangered species, threatened species, etc. but we do not map these locations because it is very sensitive and confidential information. We do not want to be distributing the locations of where these species live. It results in poaching, and it's just not a best practice. But certainly there are other policies within section 6.1 of our official plan that outline our intent to protect these areas and protect the lands around these habitat areas, significant wildlife habitat, etc., where that has been identified through studies as a result of a Planning Act application. The Rideau Corridor landscape strategy, whether or not that's been factored into these proposed recommendations tonight, and the short answer is that no, it has not factored into these recommendations, because our official plan is already seeking to implement some of those recommendations through development setbacks along the waterway and bringing in the cultural heritage recommendations. But I think it needs to be kept in mind that the intent of this work and this discussion paper is to look at how we can best implement the existing official plan policies into our new zoning bylaw. So we're not looking at bringing in new official plan policies or better implementing recommendations from an existing study through this work we're talking about this evening. We're looking at our existing official plan policies and how we can implement that into our new zoning bylaw. There was a question on the ownership of the 30-meter setback, and the 30-meter setback is intended to make sure that development is maintaining an appropriate setback. The recommendation coming through the zoning bylaw is not into ownership or transitioning that land into public lands. Certainly through development applications, that may be something that is subject of much consultation and discussion between development proponents and the municipality and the public. But the work here this evening is to make sure that development is maintaining that space. The ownership of that space can be sorted out through development applications. Question on trails, whether or not the trails are to be included inside that 30-meter setback or outside that 30-meter setback. I think the intent of our official plan and what we're trying to bring in here is trying to maintain the greatest development setback as possible from development to these sensitive features. So if there was an opportunity, like a development scenario where a waterfront pathway was being contemplated or required, hopefully that pathway could be located beyond that 30-meter setback so that we would be securing as great a setback as possible. But if it's not feasible, our official plan does allow for passive recreational uses within that 30-meter area, provided they're designed sensitively, those types of things. So that answer kind of depends on the development scenario as well. Mr. Hargreaves had some comments. And he was echoing some of the questions that members of council had this evening. So I think we've responded to a number of those questions, and I think we've got some other areas where we've heard from council where we need to do some more work and kind of further develop some of those ideas. Ms. Schmolka had a number of comments. I'm not sure that I'm going to be able to respond to all of them here this evening. I think her comments on climate change, I think is well noted. The new provincial policy statement does emphasize the wording on climate change and preparing for the impacts of a changing climate. But again, I think the scope of this work also needs to be kept in mind in that regard, where we're not undertaking a comprehensive official plan amendment here to bring our official plan in line with the new provincial policy statement as of yet. What we're trying to do is implement the existing official plan policies into the new zoning bylaw. And we've identified a few areas where the existing official plan may benefit from some amendments in order to facilitate that work. But certainly trying to make development maintain a greater setback from water bodies and environmental features, and trying to offer protection for a greater level of protection for these features in the zoning bylaw than what exists now is in line with those concepts of preparing for changing climate. We're locating development farther away. We're providing opportunities for mitigation measure. We're providing opportunities for things like soil erosion and vegetation cover, increasing forest cover within the urban boundary, promoting stormwater infiltration, where the development setback and this 30-meter setback provides space for all of those beneficial processes to occur. So it's not in line with the new official plan, but this work was not intending to update our official plan to be in line with the new provincial policy statement. There were a couple of comments on the municipalities selected for the municipal comparison review, and I think that we could chat at great length about the planning policies of various municipalities within the province of Ontario, and the pros and cons of those processes. But I think what is really important when we're trying to understand how best to implement natural heritage policies and regulations in a zoning bylaw is we need to be looking at least partially to municipalities that are within the same region, that have very similar environmental features as our own jurisdiction does. We did look to our neighboring municipalities to see how they are experiencing these issues and tackling these issues. But we did also look to other larger regional municipalities, such as the City of Ottawa, the City of Barrie, City of Peterborough. These are all other municipalities that we thought might have similar development pressures as the City of Kingston, might have similar historic downtown cores as the City of Kingston, other municipalities that are fairly advanced in their planning processes. So we did try and offer a breadth of municipalities to draw from in that municipal comparison review. There was a question about mortgages and whether or not the concern about mortgages is fear or fact. I think that the short answer on that is, did we call up TD Bank, or did we call up whatever mortgage broker and say, hey, is there a problem with this for this particular project? We did not call up those mortgage institutions for this particular project. But something that planners face on a daily basis are calls from the public, and they range from almost an impossible scale. And we hear probably weekly about people who are put in offers for purchase on particular properties, and they need a zoning compliance letter right now because their mortgage institution or their lending institution has this concern, or they need to confirm that second residential unit is legal, or the zoning permits X. So we're fairly confident that mortgage institutions do withhold financing if they do not like the zoning that is applied on a property. Additional comments on the director's discretion. I think there's been a lot of concerns and questions looking for further development of that idea. So I guess I'll just indicate that we've heard that, and we'll be taking that back and taking a closer look and trying to further develop the idea of site plan control. Acknowledging that Mishmoka does not agree with the proposed 10 by 10 structure, the exemption for a 10 by 10 structure. And I think that Mishmoka also had a point of considering existing development differently than new development, and whether it makes sense to allow an exemption for new development. I think that's an interesting point, and I think that's something that we can take away and further develop to some degree, but or at least look at the potential of applying a reduced setback for a smaller structure to still allow small garden shed in people's backyards, or a small 10 by 10 structure, because if a deck, if we don't, we know that people develop extensive patios, which often have a much larger impact or footprint than a small floating deck. I think those were all of the comments that I wrote down from Ms. Schmoka. Ms. Rudy also had concerns about director discretion, so I'll just indicate we're going to further review that and try and further develop that particular concept. There was a question about and asking for clarification on what site plan control is and how that differs from the zoning bylaw. So the zoning bylaw is the document that outlines what you can and can't do with your property, whereas site plan control doesn't determine what you can and can't do. Site plan control is looking to ensure that that property can be laid out efficiently, safely, effectively. And it's a Planning Act approval, so it opens the door for municipalities to ask for studies and submissions for you to demonstrate how you're going to develop that property. So in the context of natural heritage features and adjacent lands, it would allow the municipality to kind of put a pause on someone getting a building permit to say, hey, we think that this land is environmentally sensitive for reasons X, Y, and Z. Let's take a closer look. If it looks like the proposed development might have an impact, then it would allow us to require more detailed review through something like an environmental impact assessment to take a closer look. And then it allows us a legal ability to implement those recommendations through a legal agreement that gets registered on title. I didn't have any further questions written down. I appreciated Mr. Dakin's comments and clarifications that he brought to the table.
Great, thank you. So that will end, unless there's some follow-up questions from the committee. That will end this portion of tonight's meeting, and we can move on to looking at schools and places of worship. Who would like to tackle those topics?
So with me for this portion of tonight's presentation is Chris Wicca, a senior planner in planning services. I will be speaking to the schools element of this presentation, and Chris will be focusing on the places of worship component. Next slide, please. So this discussion paper provides a foundation that would allow for schools to be treated the same regardless of their funding model, and identifies potential amendments to the school definitions to focus on the use rather than the users. The zoning maps of the second draft will also be amended to provide a more appropriate zone for schools within the neighborhood context. Staff have identified an opportunity to permit complementary uses in places of worship, such as commercial, office, community centers, cultural and educational uses, and catering kitchens, along with permissions for additional residential units where they are located in residential zones. This is intended to support the viability of both the place of worship and the surrounding community by supplementing their principal function with additional options benefiting the community. Next slide, please. Elementary schools are traditionally the center point of residential neighborhoods. Younger school-age children are typically dependent on caregivers for safe transportation to and from schools, so that the location within a neighborhood is important for pedestrian safety. Secondary schools, on the other hand, traditionally have a wider catchment areas and have children who are more independent and mobile. With more complex and multifaceted transportation network, secondary schools are more often located on larger arterial or collector roads. The official plan recognized the location differences with separate policies for elementary and secondary schools. The official plan policies also make distinctions between private and public school. They treat public elementary schools differently than private elementary schools, allowing public elementary schools in residential, hamlet, and rural lands designation, while private schools are only permitted in institutional or commercial designations. The official plan also treats private and public secondary schools in a manner that is more similar, with both being allowed in institutional or arterial commercial designations. The difference is that public secondary schools are also permitted in residential designations where a site has adequate size and is located on an arterial or collector road. Next slide, please. The Upon review of the comments received on the first draft of the new zoning bylaw, staff identified a desire to remove the funding distinction from elementary schools and secondary schools, which would enable public and private schools to be located in the same zones. The proposed official plan amendment would continue to distinguish between elementary and secondary schools, but would remove the specific language related to private and public funding. In the discussion paper, staff identified that elementary schools would be permitted in residential, hamlet, and rural lands designations. Staff are also considering the appropriateness of allowing elementary schools in institutional or select commercial designations. Private and public secondary schools are proposed to remain in the institutional and arterial commercial designations. Applications for secondary schools within a residential designation would proceed through a site-specific zoning bylaw amendment. The second draft of the new zoning bylaw would then be amended to allow elementary schools and secondary schools in zones that align with official plan designations. Next slide, please. In response to the first draft of the new zoning bylaw, which contained a specific definition of school that was connected to the curriculum that is taught, staff received comments and concerns from members of the public that the definition would inadvertently prohibit specialized schools or other private schools teaching alternate curriculums. Staff have identified potential definitions for elementary schools and secondary schools that would focus on the use as an academic institution without reference to the school's curriculum. So the two proposed definitions are provided on the slide and they're contained in the discussion paper, but I don't think I need to read them out loud here. Additionally, staff have reviewed the proposed zoning of schools across the city from the first draft as identified in Exhibit B to the discussion paper, and have identified opportunities to better align the zoning of elementary school properties with the zoning in the immediate neighborhood of the school. Next slide.
So I'll be speaking to the places of worship section. So just as background, first of all, generally speaking, places of worship are designed for a variety of uses within the structure. So they're obviously intended from a religious gathering perspective to accommodate large gatherings. And in addition to the larger gathering spaces, they often have extensive kitchen facilities, washroom spaces, oftentimes auditorium spaces, and office spaces as well that are all located within the building. Just as Laura mentioned regarding schools, places of worship are generally speaking community gathering points. And so this means that they've been traditionally located in central locations, areas that are often located near express transit routes and near commercial facilities, although sometimes they're also located integrated into residential neighborhoods as well. By the nature of their use, oftentimes places of worship are used intermittently. Obviously, Sundays, the most part, Saturdays sometimes, and the weeknights. But oftentimes there's a latent time where the facility is not well used. It's also well known that places of worship have traditionally been places that have offered social supports. So, for example, spaces for Alcoholics Anonymous or for community groups to use the space to hold meetings, this kind of thing. It's generally recognized that the user bases for places of worship have been changing and oftentimes diminishing in recent years. And there are a number of studies out. Obviously, we've seen change in some buildings in our community where it's no longer a place of worship and has been reused for some other type of use instead. And a lot of places of worship are seeking these alternative ways of funding their operations and ensuring not only that they're viable from a funding perspective, but also that they are relevant to the community in terms of providing services to the community as well. Next slide, please. So from an official plan perspective, currently places of worship are permitted in commercial lands and institutional lands, rural lands and hamlet designations as well. And they are permitted in residential designations subject to requirements such as the provision of potable water and parking and landscaping provisions as well. They're also permitted in employment areas as complementary uses, obviously there with the recognition that they don't preclude the development potential on adjacent parcels due to their potentially perceived sensitivity. Next slide, please. From a zoning perspective, currently in our varied zoning bylaws, places of worship are generally defined as a building dedicated to religious worship, and they often include uses such as a daycare center, a hall or auditorium, Sunday school, a parish hall. They're permitted in a broad variety of zones currently, including residential and education and medical zones, commercial zones, and also open space zones in terms of things like a chapel. And in terms of the proposed zoning bylaw, which is effectively a consolidation of the current uses, there hasn't yet been contemplation of the way that flexible uses could be integrated into these existing places of worship. Next slide, please. So what we're proposing today is to add new complementary uses to places of worship. So some of the uses that were previously mentioned include things like cultural and educational uses. So that would be something like a library or art gallery, museum, school. Oftentimes these are already effectively part of places of worship. Again, like I mentioned, these are places that are used as effectively as community centers, small community centers. So they represent a really excellent opportunity for social and cultural gathering spaces. Oftentimes there's been quite a lot of interest from places of worship to be able to incorporate uses, for example, a cafe or a laundromat into their facilities to be able to better serve the community and create that social space. And beyond this, as was mentioned, in terms of the commercial kitchen element, it provides a really excellent opportunity for businesses, for example, who need to access a commercial kitchen to be able to carry out catering or to create goods to be resold, for example, at local markets. It also represents an opportunity to be a venue for sales or for, say, music rehearsals or practices or concerts, this kind of thing as well. As I mentioned, places of worship are also currently many incorporate office spaces, and sometimes in these instances there might be surplus spaces as well. This represents an excellent opportunity for things like shared spaces, small offices. I'm sure you're all very familiar with the sanctuary, which is a co-work space, which is the entire use of a previous place of worship, but clearly that's something that's functioned well in our community. And from a residential perspective as well, there is opportunity. Many of you probably are aware of residential facilities traditionally being located with places of worship, for example, and associated manse. But it also represents the opportunity for a second unit, both in terms of something being incorporated into the building itself, or in the instance where there are larger grounds, there's the opportunity for a detached second unit, which again is something that as of right is possible in a lot of residential zones. It's also possible to consider things like supportive housing, short-term housing for people who are in crisis, that type of thing, which seems again to be a natural extension of the places of worship's intended goals in terms of supporting the community. And also many of the places of worship in the Kingston area have currently cemeteries in their open space components as well. I just want to note as well, one thing that I don't have in the slides here is that from a complementary perspective, a lot of the places of worship in Kingston also have heritage elements to them. So either they're designated or listed properties. And this is something that offers an opportunity again to preserve and support those heritage characteristics. Some of the potential considerations that we've been taking into account as well are the potential for adverse impacts that would relate to the addition of complementary uses as well. So a couple of examples here would be related to additional noise or problems related to parking for the places of worship. And then there are other considerations as well that need to be taken into account in terms of making sure that additional uses would be in compliance with the Ontario Building Code, and that they would be captured from a property tax perspective, and that any additional uses would also be captured from a licensing perspective. Next slide, please. So we welcome any questions.
Thank you. We'll open it up to the committee, and then we'll open it up to the public. Any questions? Yes, Councillor Hill.
So surprisingly, my questions are going to be about schools. And I'm going to start with sort of I guess the trying to get an understanding of how this worked in the past versus how it works now. So previously, land was set aside in residential areas so that schools could be developed, right? And then the school board would have to make the decision to take it up or not take it up. I know that, you know, in recent years there hasn't been a significant uptake in those properties, but you know, we're going to go through another kind of cycle, I suspect, soon where they may. The difference between a publicly funded school and a private school is a business. And, you know, where I think you can have some expectation over time that a publicly funded school will continue to exist there, or they have to exercise their options for taking that property off of their inventory, which means they offer it back to the city and you know, different kinds of other options. In the case of a private business, private businesses come and go. You know, private schools come and go, and their longevity typically isn't as long for most of them. You know, I think we tend to think of schools as more like Upper Canada, private schools as Upper Canada College and that sort of thing, but many more private schools are small operations that don't necessarily, you know, endure, right? So I guess my concern would be that the intent of setting aside land for public education is not being met in the case of private education. And secondly, if a private school purchases that, or opts to purchase that land, you know, it does two things. One of them is it potentially undermines the public education program, and I know that's not part of land use. I understand that, but it is you know, I think something that needs to be considered. But also, if it doesn't succeed, does that provide them with the option to then sort of sell that building to another business, any other business that would want to come into that facility or that property? I don't think that's consistent with what was intended when we designated school lands in residential areas. So that's one question. Do you want me to ask both my questions first, Mr. Chair?
It's up to you. I see.
No, let's get that one answered.
So
Let's answer that one first, and then I'll have another one.
sounds good.
Through you, Mr. Chair, thanks for your question, Councillor Hill. So I think when we're talking about as of right permissions in the zoning bylaw, it's separate from a subdivision process where we're creating new parcels of land and determining how those new parcels of land are going to be allocated for the public school system. So what we're talking about in the zoning bylaw is really looking at those existing parcels of land and acknowledging that there are privately owned elementary schools that are located in zones that right now aren't designated that institutional or commercial zoning. So it would mean that while we're creating a new zoning bylaw, we would be creating legal non-conforming uses and creating a lot of additional restrictions on existing private schools within those zones. It would also prohibit private schools from being able to move their location from one property to another property, but it certainly isn't intended to change the way that lands are created for the public school system and all of a sudden open up a different process for private schools. It's really just those zoning permissions on the existing parcels and has nothing to do with that subdivision process, if that makes sense.
Absolutely. Thank you. So and actually that takes care of my other question then as well. So thank you.
Thank you. Any other questions from the committee? Yes, Councillor Vice Chair Kiley.
Thanks, Mr. Chair. I'm just wondering, staff mentioned different definitions or different land use for elementary and secondary schools. What about sites where it's joint? Would it just be some type of bulletin that's site specific?
Through you, Mr. Chair, I think the intent in the new zoning bylaw would be to acknowledge that where a school is a joint elementary and secondary school, that it would need to be located in a zone that a secondary school is permitted, because those are the more restrictive zones. So it wouldn't all of a sudden be opening up all of those elementary school zones to secondary school zones, but it would be opening up the secondary schools to the elementary schools.
Makes sense. Yeah, good. Thank you.
Thank you. And I think I saw Councillor Hutchison scribbling away there. So go ahead, Councillor Hutchison.
I was scribbling away. I hope nobody thinks that I'm looking down. I'm not listening to them. I have the same concerns as Councillor Hill, just to be really clear. Okay? And I did not understand the argument about remove the curriculum type. It seems to me that the Ministry of Education indicates you have to meet certain standards. It doesn't matter what kind of school you've got. So I didn't see what that argument was supposed to be about. And the funding, I think Councillor Hill pointed out, is, one is public and the other is private, and to some extent makes all the difference. So what I would like to know is, usually when someone applies to put this is just an example of what I'm getting at, put a school in, for instance, for the Kingston Secondary School, they looked at like a dozen different locations, some of them private, some of them public. And they would have applied for a bylaw change, and they probably would have got it. Okay, so in most cases, I mean, it was very contentious, let's face it, so you can't say for sure. But I want you to explain to me how this change in zoning will actually work. Give me some examples.
Yes, Ms. Flaherty.
They find a property that they like and they apply. And what does this zoning change do for them?
So through you,
they didn't already have anyway.
Through you, Mr. Chair. I just want to clarify your question related to the curriculum, so and to the funding type. So as we're going through the new zoning bylaw, we really want to ensure that the zoning bylaw is focused on the land use. So we're actually looking at like a school as an academic institution, and whether that academic institution is a specialized school for children with special needs who may not be teaching the exact curriculum that we've defined in the zoning bylaw, or whether it's a standard traditional school who are following that exact definition. From a land use planning perspective, we want to ensure that we're actually focusing on that use as an academic institution and not distinguishing it based on the types of curriculum that is taught. So I just wanted to clarify that the intent of this is to ensure that we're being inclusive and that we're not focusing on something that's taught at these schools, and rather the land use impacts that have a potential impact. When we're actually looking at the permissions in the zoning bylaw, ensuring that we aren't focusing on the funding model or the users of those spaces is really important for existing schools more so than for future schools, because I think, as Councillor Hill has pointed out, the majority of new schools are created when new subdivisions and new populations of residents are anticipated in an area that isn't already supported by a school. So traditionally, when you're creating a new school, it would be going through that subdivision process, and the lands would probably be zoned exactly for that school use because it was considered through that whole planning process. What we're really talking about here, for the most part, would be the existing schools and existing private schools, where there are some existing private schools that are located in residentially zoned lands. And what the new zoning bylaw would be doing would be to enable them to continue as permitted uses on those properties, and in a way that allows them to put an addition or an expansion on the property without going through a rezoning application because they don't conform with the zoning bylaw. So what we're hoping to do through these amendments is to really ensure that the zoning bylaw adequately addresses the existing schools, and then future schools, maybe they might not need to go through a rezoning application, but they might. So it's certainly more about the existing schools than the future schools that would be created through a plan of subdivision most of the time.
Okay, good. Thank you. Your point about the rezoning and not having to go through that process makes a lot of sense. And I didn't realize there are so many schools that didn't have the right zoning, but somehow they occurred. Do you know why? Is it because they start off really small and then some of them are in old schools? Like I've got at least 2 like that in my district.
Yeah, I certainly couldn't take a guess at how the existing zoning on many of the schools was created or how the existing sites were chosen, because when you look at the exhibit that I've attached to the discussion paper, there are a wide variety of zones that apply to the existing schools across the city. So what we're really hoping to do is come up with a more cohesive approach to schools and not just consolidate that existing patchwork of zoning and hope that for the best.
Okay.
Thank you.
Good planning principle. Hope for the best. Okay.
Thank you very much. So, any other questions from the committee? Seeing none, could you take the chair very quickly, Councillor Kiley? Perhaps I missed this because I did a speed read on all of this after too many Zoom meetings yesterday, but I appreciate that we're trying to kind of level the zoning playing field, if you will, for private schools as well as recognizing public schools. I know from some high schools I've taught at, there has been a daycare program or a preschool program. What is the zoning situation for those private preschool or, and pay attention, Rob, you may need to know this. So whereabouts are we with zoning for daycares, for instance?
Through you, Mr. Chair. Obviously within schools, so if a daycare would be co-located with a school, it would be considered an accessory use that's permitted on a school property. So much like any of the additional programs that schools might have as it relates to maybe auto body shops or different technical programs, they're all considered to be part of the school and certainly continued to be permitted uses on those properties. And we're not looking to limit the range of educational experiences or the daycare setups on any of those schools. And like the early on programming.
I wasn't questioning that them being situated in schools. I was about the private daycares. Have they got a kind of level playing field for zoning as schools do?
Through you, Mr. Chair, yes, I think in the second draft of the new zoning bylaw, obviously we don't have details related to daycares because they weren't the subject of this discussion paper, but we certainly are carrying the same principle forward that we aren't distinguishing daycare based on private versus public. And I actually have 2 children who are in daycare, and I think most of the daycares across the city are privately owned. I'm not sure of any publicly owned daycare. So it's certainly in the new zoning bylaw, it wouldn't distinguish on that funding type.
Thank you.
You have the chair.
Thank you very much. And Councillor Rosanek, did you have any questions? Your kids are all grown up and off to university now. So.
No, Mr. Chair, I can't compete with the knowledge of the teachers that are part of this committee. I can't compete with any questions from me.
Good point. So we'll open it up to the public. Madam Clerk. Is anybody waving a hand?
Thank you, Mr. Chair. I'm just going to remind members of the public, if they'd like to speak during this portion, if you could please raise your hand in Zoom, which is located in the center of your screen when you move the mouse over the Zoom window. I'm just going to give a couple of seconds here, Mr. Chair. We don't currently have any hands up, but if we could just give a minute to, in case anyone thinks of something that they would like to ask. And Mr. Chair, there are currently no hands.
Okie doke. Well, I'll declare the public meeting portion for tonight closed. And we'll turn to page 5, which is the all of the other things that come on all of our meetings, and we'll race through these. Motion to I call the meeting to order. Approval of the agenda. Thank you, Councillor Kiley, Councillor Osanek. All those in favor? Carried. Disclosure of pecuniary interest. Anybody opening a private school? Seeing none. Delegation or delegations. We have none. Briefings, we have none. Motions, we have none. Notices of motion, we have none. Other business? Seeing none. Correspondence, we have received some and it's been duly collected. Date of our next meeting is Thursday, May 6th at 6 p.m. Motion to adjourn. And we can pick anybody because everybody's hand went up except Councillor Kiley. Councillor Hill and Councillor Hutchison moved and seconded. All those in favor? Carried. Thank you very much.